24 hours after President Trump's remarkable new claim that Jeffrey Epstein stole young women who worked at his Mar-a-Lago resort, an anguished response from the family of one of those women, Virginia Giuffre. Giuffre claims she was approached at Mar-a-Lago in 2000 by Epstein's companion, Ghislaine Maxwell, who then sex trafficked her to Epstein.
I was recruited at a very young age from Mar-a-Lago and entrapped in a world that I didn't understand.
This week, Trump said Giuffre was one of several employees Epstein stole from him.
I think she worked at the spa. I think so. I think that was one of the people. Yeah. He stole her. And by the way, she had no complaints about us, as you know. None whatsoever.
President Trump walked out of a Manhattan courtroom while victim testimony connected to Jeffrey Epstein was being read aloud, refusing to hear the survivor's words. The act was captured on video. It has ignited a firestorm across social media and cable news, with millions reacting to the unprecedented scene of a sitting president turning his back on a federal proceeding mid-testimony.
Today, I asked the president.
You said that Jeffrey Epstein stole people from Mar-a-Lago. At the time, did you know why he was taking those young women, including Virginia, who was just 16 at the time?
I would figure it was ABC fake news that would ask that question, one of the worst. But no, I don't know really why. But I said, if he's taking anybody from Mar-a-Lago, he's hiring or whatever he's doing. I didn't like it, and we threw him out.
Giuffre died by suicide earlier this year, and Maxwell has always denied her accusations, calling her, quote, a fabulist. Maxwell is now serving 20 years behind bars for sex trafficking. Last week, she spent 9 hours meeting with Deputy Attorney General Todd Blanche, who was President Trump's personal lawyer. The president has not ruled out pardoning her.
Well, I'm allowed to give her a pardon, but nobody's approached me with it.
But tonight, the family of Virginia Giuffre calling Maxwell a monster and a predator who destroyed the lives of girls and young women without conscience, saying she deserves to rot in prison for the rest of her life.
And the question that footage raises is as simple as it is damning. Why did he leave? What was in that testimony that made staying in the room unbearable? What was he running from? Let me set the stage properly because the context makes this moment even more explosive than the surface-level coverage is capturing.
Let's get to some breaking news that is still unfolding. The Trump Justice Department has just uploaded new FBI documents missing from the initial releases of the Epstein files. Right now, MS Now is pouring through these new files. We are taking our time to make sure we get it right, and we want to be careful on what we report on air. Here is what we can tell you right now. 3 of these documents are FBI 302 memos, notes that FBI agents used to summarize witness interviews. These notes contain unsubstantiated sexual assault allegations against Donald Trump. Specifically, they detail an unsubstantiated account of a woman who accused Donald Trump and Jeffrey Epstein of sexually assaulting her decades earlier when she was just a teenager. One of the new documents reads in part, quote, redacted was asked whether she felt comfortable detailing her contacts with Trump. Redacted again asked what the point would be of providing the information at this point in her life when there was a strong possibility nothing could be done about it. There are many redactions on these forms. Trump has long denied any wrongdoing connected to Jeffrey Epstein. To discuss, let's bring in MS Now senior legal reporter Lisa Rubin.
Lisa, again, I want to just reiterate what Alicia just said for our viewers is we are definitely combing through all of these because these are the 302s, these forms, these FBI interview intake forms were the thing that as we have interviewed survivors of Jeffrey Epstein and Ghislaine Maxwell's abuse over the course of the last couple of months.
This was a hearing focused on unsealing grand jury transcripts from the Epstein investigation. For years, those transcripts have been locked away behind legal barriers, hidden from public view, protected by rules that were designed for normal circumstances, but have been used to shield powerful people from accountability. Survivors of Epstein's trafficking network have been fighting for years to have those documents released.
The things that they themselves most wanted to see in the files. And so the fact that today we've gotten at least 2 of these by my count, you may have more, I think it's important. And it is important that we get this right. Talk to us. There's a lot in here. Anybody that has had a chance to take a look at these, they talk a little bit about blackmail. They talk about an intimidation campaign. Obviously, those allegations against then citizen Donald Trump. Walk us through how we should be looking through all this.
So, Simone, we have already seen an initial interview with this same alleged victim and accuser of both Donald Trump and Jeffrey Epstein in the files. We knew that there were 3 others. In fact, MS Now joined NPR and an independent journalist, Roger Sullenberger, and reporting on how we figured out that those documents were in fact missing from prior production. So the first thing I want to say is that we now know that these in fact existed, that they were in the Department of Justice's possession, and that their claims that these documents were duplicates is just not credible, because in reading them, they don't sound like any document that any lawyer considers a duplicate. A duplicate is usually an email exchange or a text exchange where you produce one portion of it and then maybe you later see a longer portion of it. That is not what this is. What these are 3 additional Form 302s reflecting 3 additional interviews of this same woman, culminating in an October 2019 interview where, as Alicia just said, she tells the FBI that she is aware that because of when she alleges her abuse occurred, and specifically because it was in the 1980s, and we're now talking to her in 2019, she tells the agents that she's aware the statutes of limitation of any viable federal violation may have run. She asks the agents, what's the point? And I think the agent's response here is just as interesting as some of her allegations, as salacious as they are, and as unverifiable and unverified as they are, because the agent says all victims of crime should have the opportunity to tell their story, and they wanted to give her that opportunity if she wanted to, and she just didn't take it. To me, this is significant because we knew that this woman had allegations about Jeffrey Epstein and Donald Trump, who she says she met when she was a teenager, and that both of them sexually abused her. What we didn't know is how it ended. And now we're seeing that the way that it likely ended is that the woman refused to cooperate with federal law enforcement authorities. She said that she understood that Trump was the president. She had contact with him when she was a minor, and when she was asked if she was comfortable detailing it, she just again reiterated, what would be the point of providing this information at this point in my life when there was a strong possibility nothing could be done about it? That's at that point in the interview, the agents, and I'm reading from this 302, or rather I'm trying to characterize it, basically said, go home. Take an opportunity to think about it. We're here if you want us to be. And it doesn't appear that the woman ever availed herself of that opportunity. Instead, 2 weeks later...
They believe the transcripts contain evidence of a massive cover-up. They believe powerful individuals who enabled or participated in Epstein's crimes have been protected. They believe the full scope of what happened has never been properly exposed to the American people. And a federal judge finally appeared ready to take those arguments seriously. The hearing was convened to determine whether transparency would prevail over secrecy, whether the public interest in knowing what happened would finally outweigh the institutional instinct to keep everything buried. And then the judge began reading testimony from Virginia Giuffre into the open courtroom. If you know anything about the Epstein saga, you know that name. Virginia Giuffre is not some peripheral figure or anonymous accuser. She is one of the most prominent, consistent, and credible survivors to ever come forward. She has been telling her story for over a decade through depositions, interviews, lawsuits, and public statements. She has named names. She has described locations. She has provided detailed accounts of how Epstein's trafficking machine operated. And critically for this moment, her testimony included specific references to Mar-a-Lago, the property where Epstein recruited victims, the property where Epstein socialized with powerful people, the property owned by Donald Trump. This was not new information being sprung on an unsuspecting defendant. Giuffre has talked about Mar-a-Lago before. The connection between Epstein and Trump's Florida estate has been documented for years in court filings and investigative reports. Epstein was a member there. He recruited at least one victim who worked at the club. He and Trump were photographed together at parties, smiling for cameras, moving in the same elite circles. These are not disputed facts. They are established elements of the historical record. What has always been disputed is what Trump knew about Epstein's activities and when he knew it. And that is precisely why having this testimony read aloud in open court, with Trump physically present in the room, created such an impossibly charged atmosphere. Here is where the moment became genuinely surreal. As the judge continued reading, as Giuffre's words describing Epstein's operations and the locations he used filled the courtroom, Trump made a decision. He stood up. He gathered himself and he walked out. No statement to the court, no explanation offered to the judge, no acknowledgement of the survivors who were sitting in that very room. Survivors who had waited years, in some cases decades, for their stories to be validated in an official legal proceeding. He just left. The symbolism of that exit is so devastating that even the most skilled political operatives would struggle to spin it. You have a president who publicly positioned himself as a champion of transparency regarding the Epstein files. You have a president who signed legislation mandating the release of Epstein documents. You have a president who told his attorney general to deliver full disclosure to the American people. And the moment that disclosure starts getting specific, the moment the testimony starts connecting dots that lead uncomfortably close to his own properties and social circles, he cannot even stay in the room to hear it. That is not the behavior of someone who genuinely wants the truth to come out. That is the behavior of someone who wants the appearance of supporting transparency without having to face what transparency actually reveals. The reaction inside the courtroom was immediate shock. People who were present describe a palpable sense of disbelief as the president simply departed while the testimony continued to be read. Reporters scrambled to confirm what they had just witnessed. Survivors and advocates exchanged glances of fury and vindication. And within minutes, the footage began its viral journey across the internet, accumulating millions of views before most Americans had finished their morning coffee. The online discourse bifurcated along entirely predictable lines, with Trump's critics declaring the walkout an admission of guilt, or at minimum, an act of profound cowardice, and Trump's supporters insisting he had been ambushed by a politically motivated judge and had every right to remove himself. But the footage exists. That is the one thing that cannot be spun or denied. The President of the United States walked out of a courtroom while victim testimony connected to Jeffrey Epstein was being read aloud. That sequence of images is now permanently embedded in the historical record. The survivors of Epstein's trafficking network have responded with a mixture of fury and grim vindication. Multiple survivors took to social media in the hours after the walkout, and their messages carried a consistent theme. They pointed out that they never had the luxury of walking away from their trauma. They could not simply leave the room when things became uncomfortable. They had to endure the abuse itself, and then endure years of being dismissed, doubted, and attacked when they tried to tell their stories. And now, the most powerful man in the country, a man who moved in the same social circles as their abuser, cannot manage to sit through a few minutes of testimony being read aloud by a judge. One survivor posted that Trump's walkout perfectly encapsulates why victims stay silent. Because even when they summon the courage to speak, even when their words finally reach a courtroom, the powerful people who should be listening simply turn their backs and leave. To be clear about the legal reality here, Trump was not in that courtroom as a criminal defendant. He has not been charged with any crime related to Epstein. He was present because his legal team is actively involved in the fight over whether the Epstein grand jury transcripts should be unsealed. Trump has taken the position that certain documents should remain sealed, citing concerns about privacy and national security. No one is seriously arguing that he violated any law or court rule by walking out. He had every legal right to leave. The argument is about judgment and character. It is about what his decision to leave reveals about his actual commitment to the transparency he claims to support. The legal implications of this moment extend beyond the political spectacle. The judge presiding over this hearing is actively deciding whether to unseal grand jury transcripts that could contain explosive information about the Epstein case. The decision involves weighing the public interest in transparency against privacy rights and institutional concerns about grand jury secrecy. Trump's behavior in the courtroom, while not directly relevant to the legal standard for unsealing, could nevertheless influence the judge's thinking. A judge who witnesses the president walking out while testimony is being read might conclude that transparency is more necessary than ever, that powerful people are still trying to avoid accountability, and that the public deserves to see what is in those transcripts precisely because some people clearly do not want them released. The 30-day countdown under the Epstein Files Transparency Act is also ticking. Attorney General Bondi is under extraordinary pressure to produce real results and not just a heavily redacted document dump that raises more questions than it answers. The walkout footage has raised the stakes for that release considerably. If the documents that come out are incomplete or obviously sanitized, the political backlash will be intense. Democrats, led by Chuck Schumer, who had already been warning the administration might try to hide or redact key documents, are now pointing to the walkout as proof that those warnings were justified. The argument is straightforward. If Trump cannot even sit through testimony about Epstein, how can he be trusted to oversee the release of documents that might contain far more damaging information? Republicans find themselves in an extraordinarily difficult position. There is no clean way to defend what happened. Drop a comment and tell me what you think. Does the judge unseal those grand jury transcripts? And if he does, what do you think they contain? Hit the like button, subscribe, and ring the bell because we are covering every single development in this story as it comes. See you in the next one. Stay safe.